did we have anybody show up for either case?
Not that I can see.
All righty. Anyone show up on your case, Mr. Morton? I don't see anybody.
No, was it? And I realized after looking over my file, I only have one going this morning. They should have received a dismissal on Wandrin, which is 7053.
Yeah, I kind of wondered it. We have 7052 on today.
Correct. Yeah, that one is moving forward. I haven't seen anybody appear, and I talked to my client, and you know, why they think there's a potential the person may be deceased, but they haven't received any actual support or communication from the family. So.
Okay. Let me get the judge and get going here.
Sounds good.
Okay. Okay, sounds good. He'll be here in just a minute, just a couple minutes. That's really weird. Oh, who do we have here? Well, I guess nope, that's part of his. Okay. I think it's odd that Mr. Koonman isn't here and Mr. Johnson, but I don't know what's going on.
Is Keith supposed to be here for something?
Yeah, let me get back in here on the Meadow Lane case. Mr.
I was going to say, I literally just was emailing Attorney Koonman on the Meadow Lane case that's going at 9 o'clock because I told him my client received payment from the assistance program on Saturday. So so I can tell you right now, which is, and I'm flipping.
Are you talking about the 7013 case right now?
Yes. Where is that file? Yes, 7013, which is Meadow Lane versus Schweifler. That one, my client just received payment from the assistance on Saturday, so I was going to go ahead and advise the court that one could be dismissed.
Oh, thank you. You know what? I didn't realize that I pulled that case up. That's why I was confused. I'm on the wrong case for the 815. I apologize. All right, but thank you for that info. Absolutely.
Like I said, yeah, just talked to my client. They said they got the payment on Saturday, so that one can be dismissed. Okay. So that one's not going to proceed. And I advised, was it Attorney Koonman on that as well? So and if he, okay. You know, so if he was only going to appear on that one, I don't expect him to probably show up.
Okay, perfect. Thank you. I'll let you go ahead and let the judge know on that one when we're finished with these two cases, or when we're finished with your case. Thank you.
Okay, so let's get started with file 217052LT1. And that is Meadow Lane versus Dorothy Wilcox. And let's see.
Mr.
Morton is here for Meadow Lane. And it's my understanding Ms. Wilcox failed to appear. Is that correct?
That is correct, Your Honor. Attorney Ian Morton of Palace Law on behalf of Meadow Lane. Ms. Wilcox, and I will be upfront with the court, there's a belief that Ms. Wilcox may be deceased, but my client does not have a certificate of death, has not received any documentation about transfer of title or any of those documentation. They've attempted to communicate with the family, but the communication has been non-responsive. So based on that, and based on the fact that the rent has not been paid, they would like to move forward to seek a default judgment for possession.
All right, and there's this is for possession only. There's no request for money judgment. So given the service by attachment, we'll go ahead with the default for possession. And let's see, are you seeking any, well, what are the terms of the default?
Your Honor, thank you, Your Honor. At this time, rents retained are $1,907.17, core costs of $164.70 for a total of $2,071.87.
Okay, but again, there hasn't been personal service, so I don't believe I'm able to enter a money judgment at this
No,
time.
you're right, Your Honor. We're only,
Okay.
my client's only seeking a possession-only action. Was it no money judgment was pled for or is being requested?
Okay, so I will sign an eviction order then if Ms. Wilcox or other residents are present, or if she's not deceased, she'd need to be out within 10 days or the court officer would get involved. So would you like to submit an order to that effect, Mr. Morton?
Yes, I will, Your Honor, absolutely.
Okay, thank you. And let's see, we've got Kieran Goodman, it says, but that doesn't look like Kieran to me.
That's
What's your
correct,
name,
Your Honor.
ma'am?
That is Gabrielle Holman. She is my client. This is Jennifer Gray from Legal
Oh.
Services.
Oh,
We're here
okay.
on
I
that.
just,
Ayers
hang on,
investigation.
okay, I just wanted to make sure that I wasn't missing anyone on the Meadow Lanes case. So
Understandable.
we'll get right to your case in a second here. So anything else, Mr. Morton, on Meadow Lane?
Not on this matter, Your Honor. I do have one other Meadow Lane case a little later that we can dismiss, but I'll let Ms. Gray move forward with her case first because I think that's timeline wise.
Okay, thank you. So let's go on to Ayers versus Gabrielle Holman. And let's see, Ms. Gray is here on behalf of Ms. Holman. And you said this is Ms. Holman here?
That's correct, Your Honor. She's in the Adult Protective Services office.
I see. Okay. And good morning, Ms. Holman. And this was Matthias Johnson was supposed to be here on behalf of plaintiff, and I don't see him. Have you had any contact with him, Ms. Gray?
I have not, Your Honor, but I will note that the summons that I received had and I can share my screen briefly for the court. The summons that I did receive looks like it said, this is it for the court. It looks right here like it says May 26th, but it says Monday, May 26th. So obviously I assumed it was today, the 24th, and I'm here, but there's a chance they could have been confused.
Okay. Well,
In all fairness.
that is obviously confusing. So let's see, what is your suggestion then that we do here today?
We could just do a quick pretrial we just need a little bit of time for discovery because I have filed a counterclaim in this case, and that's it.
Okay, well, that's what we'll do is just set this out to our next landlord tenant day. That'll give you an opportunity to speak with Mr. Johnson about the case, see if maybe there's some resolution that can be reached, and we won't hold it against Mr. Johnson for failing to appear or his client this morning. So is there anything else we need to take up at this time, Ms. Gray?
Nothing further at this point. Thank you, Your Honor.
Okay, well, thank you for your appearance. And Ms. Holman, we are all set for this morning. I'm sure Ms. Gray is going to be in contact with you, but you're all set and you can log off at this time if you wish, okay?
Thank you.
Thank you, Your Honor.
Okay, thanks. All right, so let's go to Town and Country next. Give me just a minute here.
And those start at
Your
9, you know that.
Your Honor, if I may,
Yeah.
there is one matter that's scheduled for 9:15. It's Meadow Lane versus Schweifler. Mr. Kuhnman's appearing on it. I'm appearing on it, but this matter I can move for dismissal as my client received payment from the assistance organization on Saturday.
Okay. So I saw, there's Mr. Kuhnman.
Good morning, Your Honor.
Let's go ahead and call that case then. It sounds like you've already got a resolution in mind. So that's file 217013LT and Meadow Lane versus Schweifler. So Mr. Kuhnman, was that an accurate statement of what's going on with the case at this time and the settlement negotiations?
Yes, Your Honor, it is. I did receive some email correspondence from Mr. Morton this morning, and I think we're all on the same page that we're going to move forward with the dismissal of this matter. Thank you.
Okay. Well, we'll go ahead and do you want me to adjourn this out to our next landlord-tenant day
No.
in case? Yeah.
I don't think that's necessary, Your Honor. My clients received the funds. We're just going to submit a basic dismissal to the court. I'll send it over to Mr. Kuhnman just to see it real quick. But we don't need another hearing. The dismissal will be submitted. Today? That's the plan, is today.
Okay. Okay, great. All right. Well, I'm glad you were able to resolve that, and I'll just look for the dismissal.
Thank you.
So,
Thank you.
all right. Thank you. And our next hearing isn't until 9 o'clock. So we'll be in recess until that time.
Hmm. Morning. 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 Good morning. Who do we have here on the Town and Country matter?
Attorney Ian Morton again with Pallets.
Ah, all right. Are all the parties present, Mr. Morton?
I know, I thought I saw, was it Mr. Hatchie start to pop up as he's in jail still, but I don't see him on the screen anymore. And then I've not seen anybody appear for, James Bolin or Cassandra Fields identified on the screen.
Okay. So I did receive an email that Mr. Hatchie wanted to be present. I wonder why they logged off. That's kind of odd. Okay, and is this a first hearing?
Neither of these matters are first hearings. The Hatchie matter, I think this is the third or fourth hearing.
Okay. Okay, and then you had mentioned, let's see.
Oh yeah, and then there was the one other one. That the other matter is a motion. So that's, a motion for entry of a writ.
On this case.
Well, no, sorry. Was it Town and Country versus Hatchie, which is 7054? This is according to my record, formally, this is the third hearing. That's scheduled today? And there's a second matter, but I think that's not till about 10. And that's Town and Country versus Bolin. This is a motion hearing for entry of a writ on a judgment that was entered back in 2020.
The second case.
Correct.
The one at 10 is a motion.
Yes.
Okay. All right. Okay, thank you. And then let's see, who's here on Northland property?
Hello, Kate Glancy here for Northland Property, and I believe that my client Michelle and her assistant Hannah Stemke are on the screen. I don't know
Okay.
if defendant is on.
This is Dr. Scott J. I'm here.
Okay.
Okay, so all the parties are here on that case.
Correct.
Okay, perfect. All right, and is this a first hearing?
It is.
All righty.
It's a hearing on our complaint.
Yeah, thank you very much, Ms. Glancy. Mr. Scott, do you have a lawyer, or are you interested in getting a lawyer?
This is Dr. J. I don't think I need a lawyer. I have a written contract.
You have the choice to have a lawyer.
I don't have a
You
lawyer
don't-
today. Thank you.
Mhm. Okay, and is your first name Scott then, and your last
It
name
is.
is Jay, is what you're
That
trying
is
to tell me? Okay,
But the title's doctor.
got it. Thank you. I sit over there, and there's another chair there. This would give you a view of that screen and the judge, but so would that over there. So whatever you wish to do. I can sit beside you. Sure. And I am, I'll talk about that later. Mr. Morton, did the other party show up for the 9 o'clock?
No, I've not seen, like I said, Mr. Hatchie is temporarily sort of logged in, but he's not available anymore. And then, so for Ronald Hatchie, no one's appeared.
Yep, okay, and I don't have a second email from the jail letting me know that something went on. I'm not sure what's going on. Okay, I'll let the judge know and we'll get started, everybody.
Thank you.
Oh dear. You know, while we're waiting, why don't you come with me for a minute? So when you're here.
You are in the Zoom meeting now. This meeting is.
Take your mask off while you're talking to everybody. Sure. Yep.
Mr. Hatchie, are you, oh yeah, I see you now. Okay.
Yes, ma'am.
All right, great.
I was going to ask, was it, if possible, we could, if Mr. Hatchie and I could get put into a breakout room as, you know, based on Mr. Hatchie's location, was it, there's limited communication
Yes.
abilities in between courts?
Sure. Mr. Morton would like a breakout room with Mr. Hatchie.
Oh, okay.
Yeah, I just found that out. So you want to slide over just a bit and I'll show you what to do. So I'm going in the record. Okay, you can sit behind me if you're comfortable. Yeah. This is my recording. And everything is.
All right. That invitation,
When I'm
Mr.
back.
Morton, should pop up right about now. All right, good morning. We're going to go to Northland Property Management versus Scott David J. And that is file 217078 LT1. And let's see, I see Dr. J on the line as well
Yes, Your Honor.
as, let's see, Mr. Glancy, are you here?
It's me, Your Honor, Kate Glancy. I'm here.
Oh, Kate Glancy, okay. Kate Glancy for the plaintiff. All right, so this is the date for a hearing in an eviction matter. And Ms. Glancy, can you give me an idea where we're at with this?
Yes, Your Honor. If I have not speak to Dr. J myself either. Know if it makes us. But this is the the date and time scheduled for our hearing. This is a matter of holding over after the tenancy has ended. We're not in a non-payment of rent situation. Dr. J has always paid his rent on time and all of that. It's just the lease term ended in January of 2021, and the parties agreed to go to a month-to-month tenancy after that for a couple of months due to because of the tenant's request, but also due to COVID, it was difficult to find another place at the moment. And so on March 30th, Northland sent the notice to quit for a one month notice to quit, equal to the rental period and to the lease term, stating that Mr. J would need to move by April 30th. So he did not move out, and that's why these proceedings were filed, and that's kind of where we are.
Okay, so Dr. J, let's hear from you. My understanding was there were some negotiations about the terms of the new lease agreement, and you weren't satisfied with those, and so what is your position here? Are you looking to continue living at Northland?
Yes, Your Honor. What I believe was when I was contacted in late December, I was informed that they were wanting to pursue a renewal, but would only do so if I allowed them inspection of the premises. And because I'm a licensed physician and I'm part of the Michigan physician program that requires me to follow safest practices, I could not allow them to enter my home and continue to follow safest practice. They continued and harassed me to say they were going to enter the home or they were going to kick me out, which I said, that's unreasonable. They then said, we're going to kick this down the road. And I then contacted the state and said, I believe they're acting illegally. I then questioned their COVID policy, and they informed me that they did not have a COVID policy. I believe this is before the current person, Hannah, took over, and the previous individual was fired because they weren't following COVID procedures. Then they offered me a renewal. I gave you a copy of the form they sent me. I even increased the rental price. They closed their portal, which is where I get my insurance and other things. They've not taken care of the property. The outside grass is unmowed. The driveway was never plowed ever since January. And I don't understand their harassment of a tenant who's done nothing but pay his rent. I'm a functioning member of society. I'm an active physician. And I believe that in some ways this is retaliatory because I'm active in the cannabis community, helping people to get their physician certifications to get medical marijuana cards. And I asked the court for understanding. I'm not trying to cheat anybody. I paid people and I'm trying to be fair. And I'm just asking for your help.
Okay, well, to be clear, I'm not here to help either side. I'm here to listen to the case and and be objective in reaching a determination. But it seems to me that, well, this is the thing, unless there is some reason why the notice to quit was not valid, or there's some reason why, some legal reason why you're entitled to remain on the property.
It was not a notice to quit. It was an offer to continue. If you see the form I gave you, they asked me what I wanted to do. I checked the box, I end the duration, and I gave them payment, which they accepted.
Your Honor, I'm not sure what form.
I gave the honor the copy of the form. The original's been returned to your client.
Okay. Well, we can have a hearing here today, but I guess I want to advise Dr. J of his right to representation by an attorney, and to his right to request an adjournment. This is the first hearing in front of this court, and that would be an adjournment to talk to an attorney and, if appropriate, to prepare for a hearing in this case. And Ms. Glancy, do you have any concerns about adjourning this out for be to our next civil court date? What's that, Ms. Odom?
The 7th of June.
Okay, the purpose would be to conduct a hearing to determine whether notice was properly given and whether there's any legal reason why Dr. J should not be evicted from the premises. So any concerns about that, Ms. Glancy?
Well, Your Honor, obviously, we feel that notice was given for the full 30 days, and it's now even been almost another 30 days. So it would just concern me because the owners of this property, my client obviously is a property manager, not the owner. And the owners are wanting to get the property back, to use it for their own use, to improve the property, and they have plans for it. So they, time is a bit of the essence for the owners in this matter. I do know that, but I also, of course, I understand the rights of Dr. J to have an attorney as well.
Okay, so is that what you want to do, Dr. J, is have some time to maybe consult with an attorney and to come back on June 7th, and we would have a hearing. And if there's any evidence or witnesses you want to present, that's the time that we would do that, as well as.
Can I confirm that I addressed information and stuff to you? Did you receive that information?
I have the information and I have reviewed it.
Okay, thank you. And so you were saying that really requires a separate hearing. I understand that there is a moratorium on evictions during COVID because of health reasons, but I didn't qualify for this because I've always paid my rent, which seems funny that I'm losing legal liability because I continued to pay. Is that correct?
All right. So this is the thing. I did review what you sent me, the letters. And at this point, I can tell you, I don't see any legal justification for holding over, but that's what a trial is for, or a hearing in this case. And so that's another reason you might want to consult with an attorney if you have concerns about whether perhaps you have some legal right to assert the moratorium as a reason for holding over. But from my quick review of what I'm aware of in this case, I don't know of any legal reason why the landlord isn't able to end the tenancy. And but again, that's why it'd be a good idea for you to possibly consult with an attorney, but
So
otherwise to prepare your defense for June 7th.
So as a physician, you're asking me to leave my legal residence and expose myself during a pandemic unnecessarily, and to then end my ability to professionally be available as an on-call physician with special needs. That's your Honor's opinion?
Well, Dr. J, I haven't made any determination in this case because I haven't heard the facts.
Fair enough.
I'm just informing you of your rights. And do you wish to take advantage of that? Come back on June 7th. Otherwise, we'll conduct a hearing right now.
It sounds like I'm uneducated, and I thank Your Honor for trying to help me as much as you are. And I will take advantage of your offer and try to become educated and do the best I can. Thank you for your time.
Okay, thank you. And so we're going to adjourn this out to, you said June 7th, right? Let's set that a little bit later in the morning, 10 o'clock, say, and we'll plan on a hearing at that time. And to address Ms. Glancy's concern, there are some generalized concerns that the landlord has about being able to get in and make some updates, I guess, to the property, that sort of thing, before they release
and I'm
it or
welcome
whatever.
to let them in. I have now become vaccinated, and I've offered through writing to say my previous objections are now expired, and they're welcome to come in and make improvements, and I'll work with the landlords. They're my neighbors. I work with the birdsees quite well. He's the person that cut my grass, and according to the property management, they told him to stop cutting the grass.
All right, Dr. J, you are always able to reach out to Ms. Glancy, that is the owner's legal representative, and discuss this with her, and I'm sure she'd be glad to talk to you some more. If just getting into the property is the big holdup here, and being able to, you know, I don't know if they've got some health and safety concerns or what, but that may be a way to help resolve the case. I don't know. But you're always welcome to reach out to Ms. Glancy. In fact, I don't know, maybe I could put the two of you in a breakout room when we're done discussing this, and you could have some further discussions. And Ms. Glancy might be able to tell you, no, there's no way we're going to resolve this, or maybe there are some conditions under which the owner would be willing to resolve it. So how about we do that and at least give the two of you a chance to discuss this. But the hearing is rescheduled for 10 a.m. June 7th. And let's see if we've got Mr. Morton back from the breakout room. Not yet. So just hang on the line there, Ms. Glancy and Dr. J. And as soon as they come back, we'll put you in a breakout room, okay?
Okay,
Thank you, Your Honor.
All right. So let's go on to the next case here. And that is Town and Country versus, oh, I'm sorry, that's Mr. Morton's case. So let's go on to Mr. Lynch's file. Now that wasn't scheduled until 9:30. Well, I guess it's after 9:30. Let's see, this is a order to show cause. And that is not as to Sarah Minor, but as to
Mr. Margot?
Yeah, Mr. Margot. And is that you, Mr. Margot, on the LG phone?
Yes, Your Honor.
Okay. And I believe we're here because Mr. Margot made some statements at the end of the last hearing that we had that did not comport with the decorum of the courtroom. And I don't know if there are any other issues with the case at this time. Mr. Lynch, I think there was a judgment signed. So, Mr. Lynch, is that your understanding?
Yes, Your Honor. We had a hearing on April 26th in which a judgment against Mr. Margot was entered. Mr. Koonman did appear for the other defendant, Mr. Salafo, and both a consent judgment was entered with regards to Mr. Koonman's client, Mr. Salafo, and a hearing judgment was entered against Mr. Margot. In addition, we did execute an order of eviction and request one with this court on May 13th against Mr. Margot only. And it is my understanding that as of May 20th, he was evicted from the premises. I believe Mr. Salafo is still living there. However, Mr. Margot, it is my understanding that Robbins did evict him. So the only matter I believe before this court is the show cause that was initiated by Your Honor.
And just to be clear, you weren't looking to evict Mr. Salafo then, it was just Mr. Margot?
Yes, at this time, Your Honor, that is correct.
Okay, and can you remind me of what the reason for the show cause was? It had something to do with Mr. Margot not being showing proper decorum in
of course, Your Honor. At the hearing on April 26th, present in the courtroom was Mr. Michael Margot, my client, Ms. Sarah Miner, Mr. Koonman, Mr. Salafo, the other defendant, and a member, and a member of the Adult Protective Services, whose name I did not have. The defendants and counsel went into a break room to try to discuss possible resolution. As the discussion continued, Mr. Margot broke down and threatened my client by saying, "I'm going to rip her apart." At which time I ended the break room with Mr. Koonman and with my client. Had a separate breakout with Mr. Koonman, was able to resolve that matter. We came before the court and Mr. Koonman and I explained what had happened in the breakout room and why we were concerned. At which point discussion further between the court and Mr. Margot deteriorated and resulting in both a judgment and as well as this show cause hearing.
All right, and Mr. Koonman, you were present for that discussion, and is that an accurate statement of Mr. Margot? He would rip Mr. Lynch's client apart?
Yes, Your Honor. My notes also reflect that statement of "you messed with the wrong fucking Marine" was said in the breakout room as well. But those were the two major statements that were inflammatory and not productive to the negotiation conversation.
All right, and so the court was not present for those statements, and I think I can take it as because you and Mr. Lynch are both officers of the court. I don't think I need to take testimony. Those are the statements that were made during the breakout room. Mr. Margot, are you contesting that those statements were made?
Yes, Your Honor. That wasn't.
You didn't say it?
I said she messed with the wrong Marine and I will rip her apart in courts.
Okay, well, maybe we should take a bit of testimony here. First of all, Mr. Margot, you do have a right to consult with an attorney. This is a show cause proceeding, and you could face up to 90 days in jail as a result of that. Do you wish to consult with an attorney, or do you want to go ahead with a hearing?
Well, I don't think I need an attorney. It wasn't threatening. It's a statement that I made. And
well, what you said, what your representation is a lot different than what Mr. Lynch and Mr. Koonman recall. And
Tomato, tomato. Your Honor, I would like an attorney now.
all right, well, I am going to appoint an attorney for you. Yeah, I see Ms. Minor is raising her hand, and Ms. Minor, I don't believe the show cause hearing really concerns you. I don't think you were on the call. And so even though you may have had something to do with the original case, I don't mean any disrespect, but there really isn't anything you could add at this point that would address the show cause hearing. So
I was on the call.
you were on the call?
She was
Yes,
she
Your
was on
Honor.
the break.
Your
Okay.
Honor, I also wanted to add to this. He has disrespected your order. He has not left my home. He's been there every single day.
Well,
And
this is Ms. Minor, this is the thing. You would be a witness to the case. I'm sorry, I didn't realize that you were on that call as well. But I think what I'm going to do is appoint an attorney for Mr. Margot. I'm aware of his financial circumstances. And so we'll go ahead with a show cause hearing, and let's pick a date that will be good for the witnesses in this case. And I appreciate Mr. Lynch and Mr. Koonman being here this morning, but I think since it's being contested what was said, that the best way to proceed would be to appoint the defendant an attorney. So go ahead, Ms. Odom, pick a date.
Our next civil day is June 7th. Do you want to have that at, we just set another hearing at 10. Do you want to have this one at 10:30?
Well, it doesn't necessarily have to be a civil day, but that works if it works okay for Mr. Lynch and Mr. Koonman and Ms. Minor.
I have no objection.
How-
Your Honor. 7 works for me.
10:30 works for me on the 7th of June.
Okay, Ms. Minor, is that going to work for you as well?
yes,
Okay, so 10:30, June 7th. There'll be an attorney appointed for you at public expense, Mr. Margot, and they should be contacting you within the next 3 business days.
Okay, thank you. Your Honor.
All right.
I have no legal, I don't know nothing about the law, but.
That's what the attorney is for, okay?
Well, how, I would like to charge Sarah Minor.
All right, well, you can talk to the attorney about that, but we're done for today. And so if you want to go ahead and sign off, you're welcome to stay if you like, but we're done discussing this case. Okay, thank you again, Mr. Koonman and Mr. Lynch, and
Thank you, Your Honor.
appreciate you being here, Ms. Minor.
Thank you, Your Honor.
Yeah. Okay, so let's see if we've got, oh, there he is. Mr. Morton is back, so I'll get the jail back as well. And I'm going to put Dr. J and Ms. Glancy in a breakout room at this time.
Your Honor, could you also put my client, Hannah Stemke, in the room as well?
Sure thing. Okay.
Thank you so much.
So, Ms. Stenke and Dr. J, you're going to need to look for an invitation that will pop up on your screen and accept that invitation. That should go out right about now.
Is Mr. Marco homeless, do you know?
Unemployed.
Oh, for gosh sakes. What are you doing?
Okay, so we've got Mr. Hensey back and Mr. Morton. So have you been able to resolve anything?
Yes, Your Honor, the parties have spoken and are agreeable to enter into a proposed consent judgment. We've agreed to enter into a writ date, judgment date of the, was it 8th? Make sure I'm looking at my calendar correctly. Was it of June 8th? So the writ date's going to be June 8th, 2021. I've advised Mr. Hatchie of his rights under MCR 4.201 in regards to the judgment not being final for those 3 business days. Also advised him of his just cause rights in regards to the fact that he still has the opportunity to be able to pay the rent on the home, as this is a mobile home community, to be able to continue to keep the home there if he wishes to exercise that option. But we have agreed to a writ date of June 8th, 2021.
All right. So is that your understanding as well, Mr. Hatchie?
Yes, sir.
Okay. So you understand that Mr. Morton is going to prepare an order, and that'll have your signature on it. He'll need to get that to you at the jail. And so long as you're happy with that, you don't need to do anything. But if you decide to change your mind because you're unrepresented by counsel today, you have 3 days to rescind the agreement. So you just need to let the court know that you've changed your mind, okay? So
yes, sir.
As far as the eviction goes, there's a date of June 8th, and you do have the ability that they're willing to take payment if you're willing to, if you're able and willing to pay the money to keep the home. You can do that, but you'd need to do it before the 8th, or the court would be obligated to sign an eviction order at that time, okay?
Sir.
Okay, so is there anything else for you this morning, Mr. Morton?
Not in this matter, Your Honor, no.
All right, Mr. Hatchie, anything else?
I might be able to get a rent payment due by the 8th. I should have some money on the 7th. Do I take that to the office at Town Country?
That would be paid directly to the community to be able to continue to keep the home in the community. Yeah.
Okay, so on the 7th,
rights, yeah.
take that right to the office.
To be able, yeah, like we talked about, to be able to retain those 90-day rights, to be able to keep the home in the community, you pay directly to Town and Country.
All right.
That would be my recommendation also. Don't count on the mail or something for a situation like this. I would take the money directly to the landlord. So, okay, anything else, Mr. Hatchie?
No, sir.
All right, we're all set then. Thank you both, and feel free to sign off.
Thank you, sir. Thank you, sir.
$10 o'clock. And so we'll be back at that time.
Okay, so we're in recess until 10 because our docket, back up at 10. I accidentally crossed it off, but okay. On our next case. Okay.
Madam Clerk?
Yeah.
One question.
Yeah. Sure.
Is there a good email address for me to mail like the defaults to and the rest of that stuff?
Yeah, you're gonna email. Well, you're gonna email everything to the district court email address. Let's see. It's district court.
Okay.
At 86th. So 86th.
Okay.
districtcourt.org.
Okay, yeah. I switched up my computer, so I'm not having all my saved email addresses. I'm having a little problem.
Oh, that's okay.
Wonderful.
Yep.
Thank you. And I'll hold out until the next one then. Thank you.
Sounds good. All right.
He's on his way up. I'll have you in a room up here, so he'll come up here and select. Okay.
let's see. So, Mr. Morton, are you there?
Yes.
Hello. Okay, so now this is the case where there's a motion, and what were you telling me about this case?
So this is a motion for entry of an order of eviction. It's one where we thought they were trying to get assistance, but they were not. There's been no CDC, and they're hugely past due because this was a judgment that was entered right around the holiday of 12/28, but nothing's been paid on it.
Okay, so it's just for order of eviction, right?
Correct. Yeah.
And I don't see that they're on my screen. Do you see defendants?
Nope. I do not.
All righty.
No.
All right. Let me get the judge and let him know. And it was started at 10. I wonder if he'll probably have to give him till 10:15. I know you've been hanging out here for a while.
You know, that's part of the fun.
Okay. Well, thank you so much for your patience.
Thank you.
Mhm.
Hmm. Hey, Michelle, if you want to log off, I can hang on a little bit longer or I contact the court later.
Okay, thank you.
Okay, thanks.
Thanks. Leave, okay.
He'll be right out, Mr. Morton. coming out.
All right, good morning again, Mr. Morton. This is file 206897LT1, and that is Town and Country versus James Boland, Cassandra Fields, and all other occupants. The case was scheduled for 10 o'clock this morning. It's now 10:24 a.m., and I don't see where either of the named defendants or any other occupant of 856 Glenview Lane has appeared. So are you asking for a default at this time?
Your Honor, this was actually a default judgment was entered on this case back on December 29th. My client has continually attempted to communicate with these parties. We're not sure if they're still there. They might have vacated. But at this time, we're asking that the order of eviction, because it's been more than 56 days, be granted and allowed to be entered. Was it no payments been made on the original judgment, which was $24,7560. As of today's date, they're past due and owing $8,503.86. And my client has no record of a CDC declaration being filed either, unless the court has different information.
Okay, I guess I'm curious, what was the reason for waiting the 56 days?
Was it beyond the 56 days, Your Honor? They had continually attempted to communicate with these parties in regards to being able to receive payment on the account. I will also say that I think this one, they were talking with them and then the talks broke off, but the on-site manager had a personal matter that took her out for about a month or two, so she wasn't around. And when they did an audit of the files and were determined that they hadn't made the payment, they attempted to communicate on multiple occasions and of recent have not received any responses whatsoever.
All right. Well, I appreciate your client at least attempting to try to prevent an eviction in this case. And so I will go ahead and immediately sign an eviction order. If you want to prepare that, I could probably get it signed today.
Absolutely, Your Honor. Was it just to confirm, I know normally we do, but maybe we missed it in this case. There wasn't a new order of eviction inside the file in front of you, is there, Your Honor?
Oh, let me check. You did submit an order granting eviction. So I'll go ahead and sign that right now, actually. And is there anything else we need to discuss?
No, Your Honor.
All right. Thank you, Mr. Morton. And feel free to sign off.
Absolutely. Thank you, Your Honor.
I think Ella needs to send that to me because I can't sign it.
Yeah, I wondered.
And I could print it and sign it that way.
Let me ask Sue what she wants to do.
Okay. I'm going to print it out just in case so I don't forget. Do you know any reason I shouldn't just remove the jail, or should I just mute it?
Don't
Okay.
remove them. I mean,
I muted it.
just mute them. If you remove them, they can't get in for 24 hours.
Okay.
this system right here is called an AS 400, and I'm able to talk to people out front at their desks, and they
Okay.
can send me messages. So that's what I'm doing right now. She's Sue Womack is our lieutenant clerk, so I wanted to see if she could scan that order to the judge that he's going to sign into our on-base system in his sign queue.
Okay.
Because I can't sign it unless it's in the right queue.
Gussie is at 10:30. Okay.
Gussie is the one that keeps getting adjourned. I'm not sure. They're still trying to work it out or what.
Adjourned from 4:26.
Okay, well, let me know if anybody shows up on that, okay? Amelia, did you get your laptop yet?
I did, yeah.
Why don't we try signing now?
Sure.
That's long.
So I signed in.
Mr. Holstrom? Good morning.
There you go. Unmuted myself.
Yeah, that's okay. Thank you. I don't see the defendants here yet. Is there any reason, do you expect them? Were they properly served?
It's their motion.
Oh, it's their motion. Okay. All right. We'll wait and see if they show up. We'll give them 15 minutes, just so you know.
You know, we can certainly default them.
Mhm.
You didn't laugh.
Yes, I suppose you'd like that. All right. Well, thank you.
This is a really esoteric issue. You know, it's just an interesting issue.
Well, unfortunately, I haven't read the motion, so I'm not sure what the issue is, but I'll learn quickly.
Well, then I can't attempt to persuade you while counsel's been muted. So,
Nope, you can't.
yeah, I don't know why Bob Cooney is a local attorney, right?
He
Who's
was
that?
our prosecutor, and he's the judge now.
Wow, let me put my foot in my other mouth, so
Yeah, I don't think I'll let him know that.
thank you. Yeah. Even if the other side doesn't appear, I probably still can't win now.
All right, well, I'll let them know that they're not here and we'll be back in about 10 minutes.
Okay, so I'll just, so I can step away for 10 minutes or 5 minutes anyway?
Oh, yeah.
Okay,
Yep,
thanks.
that's fine.
All right,
Thank you.
take care.
Mhm.
Living out your window. It's weird because I took a walk then at 7:30 this morning and I'm all fucked up again and it's happening 3 hours and 15 more than one every 46 hours. Yeah. up a tree called. He's waiting to get online for a hearing, so it's gonna be brief. He's got a Zoom hearing. It's gonna be brief. He says.
You know, there's something like a contradiction in terms for me to be brief. Yeah. And the answer is I sent everything on to Ann over on Friday. I reached out to her. No. Really? Yeah. I mean, yeah. Exactly. No problem. I told him if I didn't hear from you, I'd reach out to you. So. No problem. I told him I didn't want to call you. Let's see. Yeah. Hey, John.
Hey, good morning.
Good morning. They were off the record.
Okay,
So
thank you. I don't know how they got on our calendar.
it just happens. It's the pandemic.
You know, you think after a year of doing Zooms, we get this thing figured out.
You would think so, but I can't tell you that I have any confidence that I know what I'm doing on them. It seems like each one is a different story.
I actually had my first in-person hearing in the Western District last Monday. It was nice to be back in court.
Wow. Who are you in front of?
I was in front of Magistrate Judge Kent.
Oh, okay. I've not met him yet.
Yeah, he was really nice.
He's the one that took over for Carmody, didn't he?
That's right, yeah.
Yeah. Yeah, so I've got him on a couple, I've got a file, but I've never met him. So were you in Kalamazoo or up in Grand Rapids?
Grand Rapids.
Grand Rapids, okay. Yes, ma'am.
For some reason, I think we're getting a humming coming from your. Let me see. Yeah, you're lighting up. Some sort of humming is coming through.
Okay. I'm not sure what it is. Let me go. Make sure I'm going to turn off my cell phone. See if that does it.
Yeah.
Any better?
No, actually.
Huh.
Maybe you want to log out and try to log back in. And do you have I don't know what could be causing that.
I don't know. I turned off the external speakers.
Yeah, what's going on?
Geez, I don't know. I'll tell you what. I'll log off and I will reconnect.
Yeah, maybe it's your microphone or something.
I don't know. I've not had it before.
Huh.
All right, let me log back in.
Thank you. Oh boy.
Yeah, that was loud.
Bad. Yes. Sir, which case are you here on? Are you here on the Gussie matter?
Yes, I am. I'm sorry I'm late. I had this, it got on my calendar for the wrong time, so I apologize.
That's all right.
For the delay. My name is John Gillum. I'm here for Defendant Chico's.
Okay, thank you so much. And this is your motion, correct?
Yes, it is.
All right, we'll wait for Mr. Holstrom to sign back in and see where we're at.
Thank you.
Oh boy.
Clerk, is that any better or not?
No, it's not. You can't hear that yourself?
Ma'am.
Oh my goodness, how odd. It definitely must have something to do with speakers or microphone or something being too close.
I don't know. I shut off my phone. I shut off the external speakers. I don't have
that
Bluetooth.
did it. Well, that temporarily it was better.
Huh.
Yeah, that's better now.
I mean, I can mute while John's talking or while the judge is talking, but if it's,
Yeah, I can't have that on my recording though. You know what I would suggest is maybe actually logging off of your computer and using your phone to log into Zoom. Are you able to do that?
I wonder if I can mute you here and then call in with my phone and see if that works, okay?
I bet that would work.
Yeah, sure.
Good morning, guys.
Okay, so you're logged in on, oh boy. So now we have a beeping noise coming.
I can hear that.
Okay, usually what happens is it's a feedback because of a microphone or a speaker or something. We've had this problem in one of our other courts. And they had to disconnect, which you disconnected speakers. What kind of microphone are you using? Just your...
Whatever's in my Dell.
You know what? I would suggest just not appearing via video and just use your phone, logging off of your computer completely.
Well,
Maybe if you don't have your phone so close to the you know, the computer, it might take away some of that.
you know, I turn my speakers off on my computer. Does that make any difference?
That's better.
Yes.
Okay, that's what it was then. All right.
There we go. Perfect.
Figured it out.
Okay, so let me...
Pardon me?
Oh, I was just going to get the judge for you. Hold on.
I was going to say I'm proud of myself. I figured that out without my daughter's assistance.
It actually sounds a lot better than the computer did.
Yeah.
I saw this new thing. It's going to be the next Zoom. It's some sort of mirror that Google is coming out with where you sit in front of it and it basically renders like a 3D image of the person you're talking to. And it looks like you're
Oh my
sitting
goodness.
across the table from them. It's
Wow.
going to be, yeah, it looked pretty incredible.
Yeah, my daughter said they use a couple different systems and they seem to have better results with that than they did with Zoom.
Ah,
As it is, I'd rather go back to being in person.
yeah, it's something comforting, and familial being in a courtroom.
Yeah. I was talking to a friend of mine, the tax tribunal is doing in-person or doing video trials. And I just couldn't imagine that. So I think that was my motivation for either tax appeal trial. It was scheduled for next month. I think that was my primary motivation. I just didn't want to have to try it by Zoom. I'm emboldened today because Phil Mickelson won yesterday.
I know, that was something, wasn't it?
It was. I played that course several years ago, and we played it on a day when the course is built by Pete Dye because there's typically a southern breeze, and we played it when the wind was out of the north and it was cold. And so I just remember just thinking, this is just a miserable course to play. It's so difficult to begin with, and playing against the wind was, all the holes were set up wrong.
Okay, so this is Gussie 8024 LLC versus Chico's Incorporated. And let me see, we have Mr. Holmstrom here for the plaintiff, and Mr. Glenn for the defense.
Mr. Gilliam.
Gilman, I'm sorry.
That's all right.
Gilliam.
And I apologize to the court for being late. For some reason, this was on my calendar for 11:30 Eastern, 10:30 Central, and I apologize for that. No disrespect to the court or Madam Clerk.
Oh, no problem. No worries. So I know we've been here on this case a couple of times in the past, and I think the parties have been trying to resolve it anyhow. But where are we at with this case, Mr. Holmstrom?
Your Honor, the parties have been endeavoring to try and find a resolution on this file, but we were unable to do so. And so defendant filed this motion for summary disposition in an effort either to sharpen the issues or try and reach a resolution by way of court order.
Okay. Are you prepared to go ahead with the arguments on motion for summary disposition then?
I believe so, Your Honor.
Yes, Your Honor.
Okay. Give me just a moment here. Okay, so this is the defendant's motion for summary disposition pursuant to MCR 2.110C10. And Mr. Gilliam, why don't you go ahead first then and make your argument?
Thank you, Your Honor. John Gilliam for defendant Chico's. This is our motion for summary disposition pursuant to MCR 2.116C10. Your Honor, this is a case that was filed for recovery of possession of commercial premises, which were possessed by my client Chico's. It's a commercial property where Chico's operate a clothing store, department store. And as this court is well aware, the pandemic hit, and in March of 2020, Governor Whitmer responded with some executive orders which severely limited or precluded my client from operating its premises. There's no dispute. Chico's did not pay rent for April or June, contesting that it was due for a number of reasons, but did resume making payments, partial payments for the rest of the calendar year 2020, July 2020 through December 2020, as we laid out in our motion. Subsequent to plaintiff filing suit and beginning in January of 2021, Chico's has made full payments on its obligations under the lease. What was at dispute was an amount of back rent, which defendant Chico's maintained it had good faith defenses that would excuse its obligations under the lease, including a force majeure provision and common law defenses of frustration of purpose and impracticability and impossibility of performance. Plaintiffs brought this suit to recover possession under the Summary Proceedings Act and pursuant to the terms of the lease. We tried to work this out, as Mr. Holmstrom has indicated, and unfortunately we're not able to do so. Subsequently, Chico's made full payment of all back due rent owed, and in fact made a payment that was sufficient to put it in a net surplus position on its rent obligations. We have asked for an accounting to make sure that there's no outstanding obligations or payment obligations owed at this time. We've not received word that there is claim deficiency. So it's our position that there is no basis for this case to proceed, as there is no deficiency which would entitle plaintiff to recovery of the possession of the premises. We laid out in the motion the material facts as we see them, that all payments have been made at this point. We also cited different provisions in the lease which we believe are material, specifically the fact that plaintiff had the option to seek this summary proceeding to recover possession of the premises, and that pursuant to the summary proceedings, the defendant had the opportunity to present its facts and arguments to the court or to the fact finder to explain why it felt it was not in default or why it was entitled to retain possession of the premises. It's our position that the Summary Proceedings Act expressly recognizes an opportunity for a tenant such as our client to cure any deficiency and retain possession of the premises, which we outlined in our brief, specifically MCL. MCL 600.5741 provides that if a jury or judge finds that the plaintiff is entitled to possession of the premises, judgment may be entered in accordance with the chapter and enforced by a writ of restitution. If it is based on the consequence of non-payment of money due under a tenancy, the jury or the judge making the finding shall determine the amount due or in arrears at the time, which amount shall be stated in the judgment for possession. Additionally, MCL 600.5744 subparagraph 7 states that if a judgment for possession is for non-payment of money due under a tenancy, the writ of restitution must not be issued if within the time provided the amount stated in the judgment with the tax cost is paid to the plaintiff. Our Supreme Court stated in JAM Corp versus AARO Disposal Inc. 461 Mich 161 that a judgment for possession is a judgment that entitles the plaintiff to possession of the premises and sets the amount due under the contract, which the defendant must pay to preclude issuance of a writ of restitution under MCL 600.5744. It's our position that we have complied with the Summary Proceedings Act, and that, you know, even if there was a deficiency in the amounts owed to plaintiff, that defendant would still have the right after a jury trial or a bench trial to cure any amounts owed and retain possession. And therefore, it's our position that under C10, there are no material facts in dispute, and there's no basis for plaintiffs to pursue recovery of the premises.
Okay, thank you, Mr. Gilliam. So, Mr. Holmstrom, is that accurate? According to the defendant, they've paid, looks like $69,000 and money that was owed. They prepaid $23,000 according to the defendant's brief. The numbers might be different. I don't know if there have been more recent filings, but do you agree that they are actually prepaid on the rent at this time?
I'm not aware of that, Your Honor. I know there's no question that they were fully paid at the time they tendered the check earlier this year. I don't know that there's been, I haven't seen any accounting that says that they're prepaid, but it is undisputed, or at least it's admitted by the plaintiff, that they are fully paid.
Okay, so isn't this some sort of force majeure or some sort of calamity, I guess, that caused the defendant to go into, get behind in the rent payments in the first place, and that's been cured? And why isn't the defendant entitled to summary disposition at this time?
Well, I think the answer to that, Your Honor, is that the law does not afford the defendant the right simply to breach and default in the terms of the underlying contract based upon the determination of pandemic. I think the biggest issue that I have is the defendants are painting a very broad stroke here and said, because of the pandemic, we're excused from performing our lease obligations. And in my brief, I pointed out that the law is clear that in a landlord-tenant case, we have a contract situation. We look to the intent of the parties, and we look to the lease agreement. And in this case, the lease specifically provides that in the event of material breach, which is in this case, the failure to pay rent, the landlord is entitled to terminate the lease. And that's what we did. We filed a notice of termination of tenancy. We attached it to the complaint for possession. And I'm aware of any case law that's developed in the state of Michigan that says that the mere allegation of pandemic allows or justifies an excuse to comply with the terms of the lease. That's what our brief relies upon. This is not a case where the defendant has said that as a result of the pandemic, we have sustained economic losses at this store, not nationwide, but at this store, which prevents this store from satisfying the terms of the lease. There's been no affidavit filed. There's been just broad brush strokes that says because of the pandemic, we are excused from performing our obligations. And again, I'm not aware of any Michigan law at this time, though there may be law developing, but at least in my research, I'm not able to find any case law in the state of Michigan that says we have a pandemic and therefore you're not obligated to pay your rent. This was a unilateral decision by the defendants. They chose not to pay rent, and then they chose unilaterally to pay a portion of the rent. And it was only after this lawsuit was filed that they decided that they would bring the lease current. But that wasn't on a whim, Your Honor. That was because the lease was at a point where it was going to terminate this spring. And the defendants were concerned that because they were in default of the lease, that they would be unable to exercise their right of renewal. And that's what's triggered their payment in full, not necessarily the court case here. They paid in full so that they could claim that they were entitled to renew the lease for an additional term. I'm just not, I think our position is that this is a contract. We have a lease document and we rely on a contract analysis that says they defaulted, and they admit that they default. And according to the strict terms of the contract, we're entitled to terminate the lease, and that's what we did. In the case law that I cited before the court says you have to look at the intent of the parties. Well, the intent of the parties is based upon the express language of the contract, and the express language of the contract says if you default or you're in breach of the lease, there are certain landlord rights, and the rights include various remedies in paragraph 15, which includes termination of the lease, and that's exactly what we did. So I understand plaintiff's argument. I think it's an interesting argument that says because of the pandemic, we're excused, but there's no support for that under Michigan law at this point. And I think the other practical issue is that if you're going to make a pandemic defense, you've got to have some economic basis to support your assertion of pandemic offense. I can't just say it's the pandemic and I don't have to comply with lease terms. I think I have to show that, my sales were down, that my costs were down, that somehow the income of the store was reduced to prevent it from paying at a minimum. And even then, I don't think you can assert a pandemic defense under Michigan law. In the case, and I touched briefly on it, I did not do a substantial brief on the force majeure clause, but I provided the court with an interesting case that says that when you've got a specific language here, that the economic defense is not a basis, the economic losses are not a basis to assert a force majeure provision. So I think, as I said, Your Honor, I've talked to counsel about this. I think this is an interesting case and has potentially far-reaching effects. I don't know if this court has other cases in which the pandemic has been asserted as a defense for performance of a land contract, but I don't think it's sufficient for the defendants to come in here today and tell this court because of pandemic, I'm not obligated to make my contract payments as they're set forth in the lease agreement. So, thank you, Your Honor.
Well, looking at the force majeure clause, section 25.13, it does say that either party will be excused from performing any obligation under the lease for the period of time equivalent to the delay if the performance of any obligation is prevented or delayed by, and I'll skip over floods and earthquakes and go right to orders of government, or any other cause similar and not within the control of that party, excluding the inability to obtain monies to perform or fulfill a party's obligations. Now, Mr. Gilliam, Mr. Holman makes a good point that the force majeure specifically excludes the inability to obtain money to perform or fulfill a party's obligation. And so how do you get around what's specifically written in the force majeure? And now that we've had a pandemic, I'm sure attorneys will be sharpening their pens with these force majeures, and maybe that wouldn't have gotten in there. But how do you get around that?
Well, Your Honor, this, and I appreciate, the question. I think what the issue for this motion is not whether the defenses have been adjudicated. Simply put, we felt there were good faith defenses to the payment of rent. Plaintiff had a remedy which they elected, which was to pursue a summary proceeding whereby they could prove that they were entitled to possession of the premises. During the pendency of this case, we paid all past amounts due. I think that, the bases for our defenses have not been adjudicated and are not pertinent at all to this motion because there is no deficiency. So as to the court question.
Well, isn't non-payment of rent a breach of the contract? I assume it's expressly a breach of contract in the agreement.
Your Honor, I think it's listed as a basis for default. However, the plaintiffs never sent a letter notifying that the lease was terminated. I think this, we're conflating this idea of a notice to quit possession, which is a statutory prerequisite to initiate summary proceedings for possession of premises. There was never any correspondence that said this lease is now terminated. We're pursuing our rights to recover, and there's impact to whether or not you owe sums going forward. They elected to pursue this remedy in the courts. We elected to pay and invoke our option to extend the lease. At this point, there's nothing for the court to adjudicate because there is no basis for plaintiff to recover possession. I think, another example would be, in a residential tenancy, let's say a tenant gets sick and is unable to work and pay their rent, but then there's a summary proceeding that's initiated. Someone comes along and provides them assistance. They're able to pay their rent. The court's not going to evict them because they've become current on their obligations. I think the same is true here. We felt there was a good faith defense or multiple good faith defenses. It's now been paid. We've actually paid their attorney fees as well. Up to the point when, the payments were made. And, at this point, we've exercised the option. I understand that, there may be a dispute as to whether the force majeure clause applies, but that was never adjudicated and is not part of our motion because as you see, we've paid and there's no basis to for plaintiff to recover possession.
Well, the other question I have is there an entitlement to the extension of the agreement? Because this was a 10-year lease term that began in April of 2011. So it would have expired April 2021. But the agreement also specifically provided for 2 5-year extensions. And I'm going to guess that the defendant has probably made, some investments in the store that, it's not going to get back if this lease doesn't continue, advertising and goodwill and all that. It seems to me there's probably some substantial value in continuing the lease at that location. But what does the lease agreement say about that? Are they entitled to their extension, or is this something that's a matter of negotiation? you know, there's a reason for a 10-year lease and then 2 5-year extensions. If both sides are still happy and they want to continue, they enter into an agreement. But what obligation is there on the part of the plaintiff to continue the lease after the 10 years?
Well, and Your Honor, let me just, for clarification, there was an amendment to the lease, which we attached as Exhibit 2 to our motion, and expressly in that amendment, the parties agreed to a new expiration of the lease term of June 30, 2021. So under the amended lease, Chico's was required to exercise its option by notifying plaintiff 90 days prior to the expiration of the lease, which Chico's did after paying all sums to become current. So yes, this is, our position is that at that point, we made the decision to pay all sums due to ensure that there was no question that Chico's was not in default at the time that it exercised the option. It did exercise the option pursuant to the lease and served written notice of its exercise of the option on April 8th, 2000. Sorry, Your Honor.
201.
It was delivered on March 8th at 9:09 a.m. via FedEx.
Okay, and that was the only requirement, is if you give notice, there really isn't any negotiation. If there had been no failure to make those rental payments, we wouldn't be here. Is that's your position, Mr. Guillaume?
Yes, I think that at this point, the issue between the parties is whether or not Chico's was able to exercise that option. And it's our position with this motion to terminate this action, because there is no basis for plaintiff to recover possession. We've brought all sums due. We've paid their attorney fees incurred in seeking our payment of the amounts due, and we've exercised the option.
All right, I know Mr. Holcomb wants to say something, but before we go back to you, Mr. Holcomb, Mr. Holcomb raised the issue that if you're going to assert pandemic as a defense in the first place, even if it is in fact a defense, which it may not be, but let's say that it is, you have to show some loss of income. And is Chico's able to show some loss of income? Is there a factual issue there, at least, as to whether the pandemic caused some loss of income? I mean, I can think of all kinds of reasons why they might have lost income and not have been able to make rent, but are those facts there for a jury or for me to consider?
Your Honor, I haven't developed those to state with certainty. I can say that that Chico's did suffer losses across the country, and I can't imagine that this store would be any different. You know, the store was prohibited from operating in person due to Governor Whitmer's orders. You know, the store was able, I believe, was able to operate some curbside online orders, but that would not be the purpose of the lease, is to operate an online store where merchants could drive up and pick up online orders. You know, if that was the case, that the premises was merely to be used as some sort of warehouse for materials, then Chico's certainly could have rented a much cheaper location without a storefront and without investing the money that they did into the premises. So I think that force majeure is one of the offenses that we raised alternatively. I think the frustration of purpose, impossibility, and impracticability of performance were also defenses. But again, none of which were developed through discovery because ultimately Chico's decided to pay all of its rent. And so in my opinion, those issues would be moot. There's no need to adjudicate them now because there is no deficiency on any rent owed.
All right. So, Mr. Holcomb, response?
Well, I just want to respond to one aspect of what Mr. Gilliam has noted, Your Honor, and that is that neither this lease nor the Summary Proceedings Act has a built-in right of cure. In other words, if, for instance, Mr. Gilliam indicated that if there was a trial and a residential tenant was determined to be in arrears, that there was a built-in right of cure that if he paid the delinquent rent, that somehow the underlying lease is revived, and that's simply not the case. I mean, during in 2020, there was moratoriums on residential evictions, which were pursuant to orders of either the CDC or the Michigan Supreme Court, but those were limited to residential leases. And once those expired, the Summary Proceedings Act does not afford any built-in right to cure that says after an order of possession is granted that the tenant now has a second bite of the apple where you can go back and pay the delinquent rents and somehow cure the lease. And I think that's the issue here, is that it's undeniable, or it's undenied, or it's admitted by all parties that there was a failure to pay when due according to the lease terms. And now the defendant's position is, well, we made it, we paid it current, so now we've cured the defect. But there's got to be a right to cure built into the lease, and there's none available that they can rely on. And again, using a contract analysis, the intent of the parties is gleaned by looking at the express terms of the contract. And there's no right to cure built in, and there's no right to cure built in under the Summary Proceedings Act. So I think that the defendants elected not to pay, and they could have, for instance, they could have filed a declaration action, had a circuit court determine whether or not the pandemic excused their obligation to perform, but they did not. And then they didn't escrow any monies. If they thought they had a true defense here, they didn't make any effort to establish an escrow. And now, only because of the fact that they knew they were in trouble because of the renewal provisions of the lease, that's what triggered their decision to pay us current. They knew that they were in violation of the lease terms because they hadn't made the payments, and they were afraid that landlord was going to take the position, which it would have, that if you don't make the payments, and you certainly can't exercise your option to renew, and that's what triggered their payments.
All right, let's hear from Mr. Gilliam on that issue. I don't know if you had others you wanted to respond to, but in the day-to-day landlord-tenant cases that I have, Mr. Holcomb is correct. There's no built-in, pay-to-stay clause with summary proceedings. In fact, I generally ask the landlord, well, what do you think in a default case? If the person comes up with the money, do you want to allow them to stay or not? And they make that call, and I sign an order to that effect. Either, they can stay if they pay or not. And I think I've been doing that right in the day-to-day typical landlord-tenant cases. So where does the law say that if you cure the defect, you get to stay?
Well, Your Honor, I'm looking specifically at 600.5744, subparagraph 7, which states that if the judgment for possession is for non-payment of money due under a tenancy, the writ of restitution must not be issued if, within the time provided, the amount stated in the judgment with the taxed cost is paid to the plaintiff. So, that certainly contemplates that the tenant is able to pay to avoid a writ of restitution and thereby, retaining possession of the property. I would also note that the lease is silent on whether, if the lease certainly says, as plaintiffs would indicate, that there is no opportunity to cure, then the lease would specifically state that. It would say that under no circumstances is the tenant able to cure deficiencies in the, past due rents that are owed. I think that by being silent on that issue and by expressly contemplating that the plaintiff can elect to not terminate the lease, which is what they did here, and to pursue termination of the tenant's right to possession of the premises, which is outlined in section 15.02A sub 2, then that puts it under the authority of the Summary Proceedings Act and this court's jurisdiction, and that's what plaintiff has done. I think that, to take Mr. Holmstrom's hypothetical to a different set of facts, let's say that we still have 2 years left on this lease, and our defenses were adjudicated, and the court said no, there was no force majeure, or there was no frustration of purpose, and you owe these 6 months of partial rent that weren't paid. And if we paid those, there's nothing in the lease or in the Summary Proceedings Act that says that we would not be able to retain possession of the premises. In fact, it says that we would be able to retain possession and that a writ of restitution would not be issued if we paid, including the tax costs. So we've effectively done that by paying their attorney fees and any amounts that potentially could be claimed as a basis for dispossessing Chico's of the premises in this case. So, we believe we've complied with the Summary Proceedings Act. We're not in default. There is no basis for evicting Chico's at this point, and we believe that the option was properly executed.
Your Honor, if I might just respond to something Mr. Gillum said. He was referring to a portion of the Summary Proceedings Act, and John, I believe it was 5774.
5744.
5744. In any event, Your Honor, I think that section relies. I think that section is premised upon a 7-day notice to quit for non-payment. In this case, we served both a 7-day notice to quit for non-payment of rent, but we also served a notice of termination of tenancy. And what I believe 5744 refers to is that in the event the plaintiff or the landlord is proceeding solely on the notice to quit, that at that point, a judgment of possession affords the tenant 10 days to pay, and that's true. But that's not the case here because we're proceeding under our notice of termination of tenancy, which indicates and is based upon the fact that the landlord has terminated the lease and is now seeking possession. And non-payment of rent is simply not applicable at that time, although it's the underlying basis for the termination of the tenancy, but there's no built-in right to cure under those provisions. And secondly, it's true, the lease doesn't specifically say that the tenant has no right to cure, but that's backwards. The intent of the parties is premised upon the exact express language of the lease. And if it doesn't specifically say there's a right to cure, you can't say that you can't say that because of the absence of specifically stating a right to cure that a right to cure is created. It's just backwards. So I think that the court's honed in on the issues here, and I think that the motion should be denied.
All right. Well, since you raised 600.5744 sub 7, I'll give defense counsel another chance to respond. I don't know. Is there anything else you want to add there, Mr. Gilliam?
Just one moment, Your Honor, if I may. I just want to review that. Your Honor, I would just note that, if this motion is denied, I don't know what we are going to, go to trial on. There's no basis for dispossessing Chico's from this tenancy when there is no amount that plaintiffs will be able to prove at trial, which is due and owing that would entitle it to possession. I would also note that if it is plaintiff's position that Chico's is in default and not able to exercise the option, plaintiffs have not complied with the portion of the lease which requires them to notify Chico's that the option is or the opportunity to exercise the option is coming up, and a decision needs to be made because as we've cited in our motion, the lease has a provision that says there shall be no unintentional waiver of the option term. And so if the tenant fails to timely notify the landlord of its intent to extend the term, then the landlord has an obligation to provide Chico's notice that it has 30 days to either exercise or not, with the only caveat being that plaintiff could have sent such a notice 60 days prior to the required 90-day notice period, which would then have excused its obligation to provide Chico's with subsequent notice. So in any event, there was no unintentional waiver of that provision. And I think that, however the court sees this motion, there is no basis for proceeding to dispossess Chico's of this property and believe that, under the terms of the lease, we have properly exercised the option, and therefore we feel that this motion should be granted and the case dismissed.
Okay, well, I'm going to rule on the motion for summary disposition. I believe Mr. Holcomb has correctly stated the law as regards 600.5744 sub 7, that is premised on a 7-day, the right to cure is based upon a 7-day notice to quit, not for the reason that the notice of termination was filed in this case, and that was for the breach of contract, non-payment of rent, and notice to terminate the lease agreement. Now, Mr. Gilliam asked, well, what is this case going to trial on? Well, number one would be the breach of contract and whether or not that occurred. And I think there's at least a factual issue there, whether there's a breach of contract and whether there may be some excusal of that. I don't know, but I don't feel comfortable that those issues have been thoroughly resolved. And so at this time, I am going to deny the defendant's motion for summary disposition. I'm not going to, well, either party may still file a motion in this case if they think it's appropriate. But at this point, the defendant's motion is denied and we'll be proceeding to trial. So with that, I want to ask the parties, I don't know what the pretrial order said about discovery in this case, but is there any additional need for discovery? Are we ready to go to trial, or where are we at? Mr. Holcomb?
Your Honor, I believe that in light of the issues we've talked about today, that we should have at least 90 days for discovery, Your Honor.
Do you agree with that? Then, Mr. Gilliam?
Yes, Your Honor, that 90 days should be sufficient.
Okay. And I'll allow a similar period of time for filing of any counterclaims or motions. And let's see. I think the parties have been working together fairly well, trying to resolve this case. You know, just my guess, but it sounds like rents have gone up in Traverse City. You know, the plaintiff's got a paying client, paid the attorney fees and everything, and is ahead in the rent. Apparently that's not enough, but so I'm guessing that the discussions have to do with the amount of rent that's being paid, but just a guess there. Anyhow, do either of the attorneys feel that there some sort of mediation would be helpful? Or again, I think you've been working together on this and you're probably capable of resolving it yourselves, but I don't know if mediation would be helpful or not.
Your Honor, I think in light of the court's decision, I think the parties will probably convene and have some discussions to see if there's a way to resolve this. So I'm confident that between the parties, we would be able to make that decision if we feel mediation would be helpful. And I don't think a court order mediation is necessarily required at this time.
Do you agree with that, Mr. Holcomb?
You know, I do, Your Honor. I think just so the court's aware, Mr. Gilliam and I we have a cordial relationship. We've worked well together. His client's a national client, and you know, I'm not sure that a court-ordered mediation is going to provide any benefit here, or at least not substantial benefit.
All right, so I won't order that. Let's see. Has either side requested a jury trial?
Defendants have.
Yeah, I believe we did, Your Honor.
Okay. All right. So we're looking at mid-July. We're looking at mid-July before we start jury selections again, and so that's going to be before we even get through the period of discovery in this case. So we're probably looking out into. We got a big backlog of criminal cases to get through, so it'd probably be October, I'm sure, before we'd ever get to trial in this case. But we'll go ahead and schedule that out, and you'll get a notice. Probably won't be right away. We still have to make some decisions working with the court administrator's office. So, all right. Is there anything else either side would like to see in the pretrial agreement?
I don't believe so, Your Honor.
No, Your Honor.
All right, so we'll get that order out to you along with the order denying defendant's motion for summary disposition. Is there anything else for either side?
I don't believe it. Thank you for your time, Your Honor.
All right, thank you both.
Thank you.
Okay.
Have a good day, everybody. Bye-bye.
Bye.
Did you have a formal pretrial form?
No, I'm gonna have to get that from Ella.
Oh, okay. Sue.
Oh, was it Sue? Okay.
Yeah.
All right. So I'm gonna log off for the morning. I made it go live stream in the afternoon. Our hearings are live streamed on YouTube because ordinarily the public has a right to be present, and they can't because the courtroom's closed.
Right. Okay. I'm rushing out to go let the dog out.